declare the results. Just a point to Moot. We are very, very impressed with your performance, both sides. Very, very impressed. And one of the good things is that you were very attentive to the bench. You responded to the bench according to the questions the bench asked you. Just a few issues. We were not sure if you were referring to the bench as your worship or lordship. So the correct word is lordship, not worship. Even some law school students, they are also confused whether to call the High Court your lordship or your worship. So for the High Court, it's your lordship. And if you cannot refer to the bench as you, you can say, I refer your lordship to, not I refer you to. A little bit about the dressing, it's okay, but using a wing collar shirt for such an occasion is something you want to look at. So overall, we'll give you 99% in our overall observations, both sides. So but now we're going down to specifics, and my Lord will now read the result of the specific assessment. Thank you.
Thank you, my Lord. Now, this is how we were assessed. We were given a guideline, and we had to follow it to the letters. The first thing you are expected to do is, as regards the content, the cover page. So for that case title, Team Edwin Clark University, case title, we didn't give you any mark, you got 0 because you didn't comply with what they said. You are expected to put on the right-hand side, on the top right-hand side, your team, your team code, you didn't do that. So we gave you 0. Delta State University, we scored 1. The site title, both schools had 1, 1. You are expected to put the year of the case, of which both of you did. We also gave you 1. The name of court, Edwin Clark University presented the name of the court, the way and manner they ought to be, and we scored you 2 marks. While the State University didn't do it properly, though you stated it but not properly done, we gave you 1. The team code with Edwin Clark University 1. Delta State University didn't state your team code, we gave you 0. In terms of articulation, Edwin Clark University scored 7. Delta State University 6. Knowledge of facts, the way and law, the way it was presented, we gave Edwin Clark University 7, Delta State University 6. Flow of argument, we gave, overall presentation, Delta State, Edwin Clark University gave you 7, Delta State University 6. Flow of argument, Edwin Clark University, we gave you 4, Delta State University 4. In terms of clarity, we gave both schools 7. Dressing, both schools 3. Set of research, both schools 7. Delta State University scored a total of 44 points, while Edwin Clark University scored a total of 47 points. So what is going to happen now, there will be another proceedings that we are going to carry out. It will be between Delta State University and the other school, I don't know the school now. Michael and Slavery University. So Delta State, Edwin Clark University, just You need to vacate the front seat. Thank you.
We are very much grateful for what considered.
It's a well considered judgment.
We are most welcome.
Where's my
Please can Eagle University come to the front? Are they here?
Michael Ibro University.
We are going to rate you on the tidiness.
My Lord, sir, the students from Michael and Cecilia Igbo University want to put on their bid because they didn't come with accessories.
They want to put on what?
Their bib and collars.
What do you mean by that? I don't understand. Okay, let them come.
See, all of us are not quite dressed anyway. I think we should just.
Just got them taken for a test. Let them go ahead. Let them get dressed, yes. Can Mr. Asuko step forward, please? Let's ask him first. Are you ready, please? Are you ready? Court is waiting. You're ready? Yes. Call the case.
Case concerning frustration contract and just shareable doubt over arbitration proceeding in a matter between Into Energy of Pefe Limited. But all the parties in this suit are absent.
Thank you. Yes, can I announce your appearance, please?
We confirm the immunity to this honorable court. In appearance for the petitioner is E.A. Onoke. And also appearing with me is V.R. Makaiba. We announce our appearance for the petitioner in this case, please.
Yes.
Before your Lordship, I am O.O. Manasseh, Esquire. With me, V.O. Chukwuemeka. For the purpose of record, my lord, Chukwuemeka is spelled as C. Most oblige your lordship. And also, we have R.O. Adam Moot, Esquire. Our humble appearance is for the respondent.
Yes. Yes.
Respondent.
You're present. You're ready?
Yes, my lord.
Yes.
Thank you very much, Your Lordship. Your Lordship, we have before this honorable court a written address dated and filed the 16th day of June 2025, praying this honorable court to determine that this contract is not frustrated and that the arbitration, the appointment of Mr. Obodo as presiding arbitrator is valid. With the leave of court, we seek to adopt this written address as our argument in this case, as we shall be relying on same. Thank you very much, Your Lordship.
Thank you.
Your Lordship, we've distilled two issues for this court's consideration, and they are one, whether in the circumstances of this case, the doctrine of frustration is applicable to discharge the contractual obligations of the petitioner under the Kara Contract Act 1872. Two, whether the appointment of Mr. Obodo as the presiding arbitrator by the Kara Institute of Arbitration violates the requirement of impartiality and neutrality, and is therefore liable to be set aside.
Mr. Manasseh, we're giving you and your team 10 minutes, total of 10 minutes.
Thank you very much, Your Lordship.
You're welcome. Yes?
Your Lordship, I'll be addressing issue 1, and R.O. Adamu Esquire, as well as Chukwuemeka Esquire, will address this court on issue 2. With the leave of courts, I seek to begin argument on issue 1. On issue 1,
Yes, go ahead.
thank you very much, Your Lordship. On issue 1, we submit before this honorable court that the doctrine of frustration cannot be invoked by the petitioner in this case. This is because frustration by its legal nature is an exceptional remedy which should not be lightly applied or invoked. This principle only set in when a supervening event strikes at the heart of a contract, thereby rendering further performance impossible. The key word here is supervening event and not merely inconvenience or delay. We refer to Honorable Courts to the case of Mazin Engineering Limited and Tower Aluminium Nigeria Limited. Citations are well furnished at paragraph 2 of our written address. The court is clear and as well noted in the case of ROMAFC versus UEC Limited that supervening event alone and law should be should be such that should make a contract frustrated. From the fact disclosed before this Honorable Court, there is no such circumstances raising the inference of frustration to be applied. By analysis, we do recognize that the subsequent lockdown of 21 days accompanying the COVID-19 was a pandemic and it constituted a destructive force. Now, both parties acknowledge the destructive force of this pandemic and mutually come together. They came together to extend the original contemplated date of December 30th, 2022 to March 30th, 2023. We submit before this Honorable Court that the conduct of the petitioner undermines argument. Now, the action of the petitioner is not one rendered capacitated by circumstances, but one seeking to exit the door of an unprofitable agreement, and not seeking to exit the door of an unprofitable agreement, and not one by the guise of seeking to rely on legal bar. Now, the court has emphasized the case of Davis Contractor Limited and Fairham UDC that mere hardship and delay should not constitute ground for frustration. We also have supporting this position National Carriers Limited versus Panapina Northern LTD. Here, this court has been judicially recognized. Citations are well provided in our written argument. We submit before this Honorable Court that the petitioner is mistaking mere hardship for frustration, and we're humbly calling on this court to clarify that doubt, and that's most in the eyes of the petitioner. Now, to accept the position of the petitioner is to create a dangerous precedent where mere hardship, inconvenience, and economic hardship can constitute frustration. Certainly, this is not the position of the law. Hence, we are humbly urging this Honorable Court that the argument put forward by the applicant is legally unsustainable and is unsuitable. Hence, we so urge this Honorable Court to so hold that the contract has not been frustrated. With the leave of court, I seek to hand over argument on issue 2 to my learned friend R.O. Adamu Esquire to submit argument briefly on issue 2. Most obliged.
Thank you, Counsel. Yes, R.O. Adamu, can we hear you?
With profound humility before this honorable court, I will be addressing this court on issue 2, which is whether the appointment of Mr. Obodo as the presiding arbitrator violates the requirements of impartiality and neutrality and is therefore liable to be set aside. Your Lordship, we respectfully submit that the appointment of Mr. Obodo as presiding arbitrator was duly made in accordance with the agreement clause mutually agreed on by parties, and that there exists no credible or sustainable ground to challenge his impartiality or neutrality. The alleged basis for such challenge, a past academic connection between Mr. Obodo and Mr. Ajayi, the respondent CEO, does not fall far below the legal threshold required to impugn the independence of an arbitrator, my lords. Upon appointment, Mr. Obono submitted a statement of independence wherein he stated that he bore no conflict of interest with either parties, my lords. And this declaration was not rebutted by any contemporaneous evidence. It was only after the commencement of proceedings, precisely on the 7th of May 2022, that the petitioner raised a belated objection on the grounds that Mr. Ajayi and Mr. Obodo were former classmates, my lord. There was no allegation of financial connection, no professional affiliation, and no indication to show that the alleged acquaintance had any influence whatsoever on the case of grounds, my lord. It is right that mere social or academic acquaintance does not in law amount to a disqualifying bias. The court has held that the standard is whether there is a real likelihood or reasonable apprehension of bias in the mind of a fair-minded and well-informed observer, and not fanciful or remote possibilities, my lord. My lord, there is nothing on the face of the facts before this honorable court to suggest real likelihood or reasonable apprehension of bias. This is even more so because the requirement of proof has not been sustained, my lords. In cases of bias or real likelihood of bias, there must be cogent and reasonable evidence presented before the court to satisfy the court that there indeed exists a real likelihood of bias. This has not been provided before this honorable court, your lordship. And we therefore submit that the mere vague submission of whimsical and capricious persons should not be made the standard to constitute proof of such serious complaints of bias. This was the position of the court in the case of Osuchi versus Ogu Alaji. Citations duly provided in a written brief of arguments, my lord. At this point, I hereby seek the leave of the court to call on V.O. Chukwuemeka to further provide this court with arguments on issue 2.
Your time is almost up. You have 2 minutes to round up.
For emphasis, my lord, I remain.
Sorry, which of the issues will you be talking about?
I'll be going to the concluding aspect of our argument.
Which is, would a reasonable man think the arbitrator and the parties being classmates? How would a reasonable man?
My lord, in answer to the question put before me by the court, my lord, my lord has to bring to the notice of this court that social and academic affiliation in certain situations might exist, and this is not within the power of the parties to prevent. My lord, in such situations, the law deems it right for the person asserting issues of bias to provide cogent and reasonable evidences to support the objections so raised. To support the objections so raised. My lord, in this particular case, the applicant only raised issues of an existing academic ties. The applicant has failed to satisfy the legal burden cast on it by the law to provide reasonable and cogent evidence, to support the objection so made. Thank you, my lord.
Was there a denial that the arbitrator and the party were classmates?
There was no denial. Yes, it was admitted, but it was the relationship and the tie was said to be in history, in past. It was not in existence as when the case originated.
Thank you.
Thank you, Madam.
Thank you. Yes, are you ready to react or respond? Yes.
written address that was dated the 22nd of June 2025. Same was filed on same date and served on both parties.
That's Evie and Onovuge. Is dated when?
22nd of June 2025.
Yes.
My Lord, I humbly seek the leave of God to adopt our written address as our argument in this case.
Yes.
My Lord, we have distilled 5 issues for determination before this honorable court. To wit, whether the High Court has competent jurisdiction to determine this matter, whether the outbreak of the COVID-19 and the subsequent lockdown imposed by the Kara government rendered performance impossible and frustrates the contract. 3, whether the petitioner is entitled to payment for partial performance on a quantum merit basis. 4, whether the appointment of Obodo as the presiding arbitrator is invalid on grounds of apparent bias and breach of duty of impartiality requirements of arbitrators. And lastly, whether a declaration, a mere declaration of independence, is sufficient where a justifiable apprehension of bias exists. My Lord, with the leave of this honorable court, I will address the court on issues 1, 2, 4, and 5, while my learned friend, V.R. Makaiba, will address the court on issues 2. For emphasis' sake, I beg the leave of court to proceed to my argument on the case.
You go ahead.
Thank you, my Lord. My Lord, on the issue of whether or not this court has jurisdiction to entertain this matter, if it pleases my Lord, we beg to answer that question in the affirmative. My Lord, Section 46 of the Nigerian Constitution 1999 as amended. However, we are not in Nigeria. We are presently in Kara. But the facts of the case expressly states that Kara is a democratic republic in West Africa, same with Nigeria, and as such, we are sister countries. And the Constitution of Nigeria is pari materia with that of Kara. My Lord.
Go ahead.
My Lord. My Lord, that section provides that when a person alleges that any of his fundamental rights is likely to be contravened in any state, such person can apply to the High Court for a redress. Subsection 2 further provides that the High Court has jurisdiction to entertain the matter and to make such orders as may be necessary. My Lord, the facts of the case clearly shows that there was a contract that was entered into by the parties. Those contracts were subject to arbitration procedures. But however, the constitution of the arbitration panel fell short of the requirements of impartiality and neutrality required of arbitrators. My Lord, as we proceed on our arguments, we will establish the partiality on the appointment of the presiding arbitrator. However, based on this, there was every likelihood of bias, and that is why the petitioner has applied to this court to sit and adjudicate over this matter, pursuant to Section 46 of the Constitution earlier cited that gives this court jurisdiction to entertain the matter. Furthermore, I will humbly refer my lords to the arbitration clause contained in the agreement, marked as Exhibit A. The first item of the arbitration clause expressly provides, I refer my lords to page 6, paragraph 2. My lord, it provides that when the arbitration procedure fails due to any reason, the matter shall be decided by the court. Thus, the arbitration clause recognizes the jurisdiction of the court to come in where arbitration fails. And my lord, the petitioner begs to humbly submit that when the appointment of the presiding arbitrator is likely to contravene the fundamental rights of the petitioner to fair hearing as guaranteed under Section 36, which implies the right to an impartial arbitral tribunal or a court. That right of my client is likely to be contravened. My client, by the provisions of the Constitution, does not have to wait for actual bias for his rights to be actually contravene, or when there is a mere likelihood, the provisions of the Constitution gives this court jurisdiction to entertain the matter. We so humbly submit that this court has jurisdiction, and we pray this court to so hold. My Lord, moving on to the second issue of arbitration. My Lord, it is our submission to this honorable court that the appointment of Mr. Obodo is invalid for apparent bias and non-compliance with the requirements of impartiality and independence. My Lord, it has been long established a principle of law, as stated by Lord Howard CJ, that justice must not only be done, it is not just of mere importance, but it is a fundamental principle of law that justice must not only be done, but it must be manifestly and undoubtedly be seen to be done. My Lords, I refer my Lords also to the case of Star Oil Nigeria Limited versus NNPC. Citations duly supplied in our written address is contained in page 10. My Lord, in this case, the court held that apparent bias is sufficient to vitiate an arbitral process or an arbitral award. My Lord, from the facts of the case, it is obvious that Mr. Obodo is a close friend of Mr. Ajayi, who is the CEO of the respondent company.
Was that the objection? Close friend, or that they were classmates?
It's a close friend. The position of the respondent that they are just mere classmates is merely misconceived. The facts clearly state that he is a friend of Mr. Ajayi. My Lord, that social connection raises the presumption and the likelihood of apparent bias. My Lord. Furthermore, Section 8 sub 1 of the Arbitration and Mediation Act 2023 imposes an obligation on arbitrators to disclose any circumstances that is likely to raise justifiable doubts of impartiality or independence. And furthermore, it states that an arbitrator can be challenged where there are circumstances which gives rise to a likelihood of bias, my Lord. And the fact that Mr. Obodo is a close friend of Mr. Ajayi, as established in the facts of the case, my Lord, it suffices to raise the presumption and the likelihood of bias on this part. My Lord, moving on.
Was it after the proceedings that you raised objection as to the qualification of the arbitrator?
No, my Lord, it was when we discovered after the appointment of Mr. Obodo, it got to the knowledge of the petitioner that he is a close friend, and the objection was raised. My Lord, on the issue of whether or not a declaration of independence is sufficient, my Lord, listening to the arguments of the respondents, counsel for the respondent made mention that Mr. Obodo submitted a formal declaration of independence. And my Lord, we beg to submit to this honorable court in reliance being placed on the case of Dr. Charles Mekunwe and Christian, reported in 2019 Volume 3 Nigerian Weekly Law Report, wherein the court held that a mere declaration of independence or disclosure of lack of conflict of interest does not suffice, is insufficient to dismiss any circumstance where a reasonable and justifiable likelihood of bias persists. And my Lord, we so hold that the facts of that case are in tandem with this, my Lord. My Lord, the social ties that exist between Mr. Ajayi and Mr. Obodo raises the reasonable apprehension of bias, which renders the appointment of Mr. Obodo invalid on grounds of non-compliance with the requirements of neutrality and independence. And the fact that Mr. Obodo later submitted a formal declaration cannot dismiss that likelihood of bias.
So the arbitrator did not deny that they were friends?
No.
He just says that we independent?
Yes.
Yes,
Yes, my Lord. My Lord, conclusively on this issue, we submit to this court that the mere declaration is insufficient to dismiss the likelihood of bias in the circumstances, and we urge this honorable court to so hold. And on the issue of frustration, my Lord, not to waste the time of this court, but frustration is a doctrine under contract law which operates to the effect that parties are discharged from further obligations arising from a contract where a subsequent supervening event renders performance of a contract impossible. Emphasis 2021, the entire Republic of Kara began to experience outbreak of COVID-19, my lord. And in order to curtail the further spread of this, the government imposed lockdown restrictions, which took effect as on the 15th day of October 2021. My lord, as at that time, we all as citizens of Kara Republic were affected by this COVID-19 pandemic and government restrictions, my lord. Furthermore, I also refer, my lord, to paragraph 3 of the statement of facts, wherein it was stated that the lockdown order was to subsist pending further orders, my lord. The contention of the respondent that the lockdown order was temporary is misconceived, my lord. The lockdown orders issued by the government of Kara was to run subsisting pending further notice. Reliance is also placed on the case of Okebola Trading Company and African Continental Bank, reported in 1998 Part 3 Nigerian Weekly Law Report. My lord, in this case, the court firmly upheld and observed that government policies applies as a force majeure, which renders performance of a contract impossible. My lords, if we consider the nature of the contract in itself, it requires physical presence of the petitioner. It requires the petitioner to be on ground, moving from one side to another, carrying logistics and all of that. My lord, all of this could not be performed remotely under strict lockdown restrictions, my lord.
Was there a time limit to performance of the contract?
My lord, there was a time limit to performance of the contract. However, the government imposed lockdown acted as a force majeure, which was not due to fault of any of the parties, my lord. And it would have amounted to an illegality on the part of the petitioner to go against strict government orders. My lord, the orders of the government was a complete ban on movements. That was lockdown restrictions, my lord. My lord, I humbly submit to this court the legal maxim, let non cogit ad impossibilia. The law does not compel the impossible. And from the facts of the case, my lord, it is clear that the petitioner could not perform his work, could not perform his obligations under the contract because of the supervening events.
Find out was whether there was lifting of the restrictions after some time.
My lord, from the facts of the case, I refer you to paragraph 3. And it's stated clearly there in paragraph 3.
Yes, what thing?
It stated, my lord, there that the government imposed lockdown for 21 days, limiting movement of the entire population as a preventive measure against the COVID-19 pandemic in Kara until further orders. This indicates that the lockdown was still subsisting. The order was indefinite, my lord. And as such, as at the initial agreed date for completion, the contract was already rendered impossible to perform, my lord. And it's on the strength of this impossibility that the petitioner, in good faith,
5 more minutes for both of you.
the petitioner in good faith communicated this legal position to the respondent. And my lord, we beg to submit that the invocation of termination, the termination of the contract by the respondent, it failed to acknowledge the legal effect of frustration of contract as it discharges parties from further obligations under the contract. I therefore submit to this court that the contract was frustrated by the government-imposed lockdown and urge this court to so hold. I seek leave of court to introduce my learned friend V.R. McIver to further address this court on issues 3.
Thank you, Counsel. Yes, McIver. Go ahead, we're waiting.
Once again, I am V.R. Makaiva,
Yes, go ahead.
humbly appearing for the petitioner in this case, my Lord. My Lord, I will be addressing issue 3 as contained in the petitioner's brief.
Go ahead, counsel.
Thank you, my Lord. My Lord, the issue before this honorable court is whether the petitioner is entitled to a claim of quantum merit on the basis of 80% work done, my Lord. If it pleases your Lordship, I beg to answer that question in the affirmative, that the petitioner is entitled to a claim of quantum merit on the basis of 80%, which amounts to substantial performance of his contractual obligation in this contract, my Lord. My Lord, the locus classicus of quantum merit is founded upon in the case of Plant versus Colborne. Details are reported in the petitioner's brief, my Lord, wherein the court established the principle that when a party has rendered services under a contract that has been frustrated, my Lord, they may recover a reasonable amount for the value and quantum of services rendered. My Lord, this principle was further affirmed in several cases, including that of Savannah Bank of Nigeria versus Oladipo Opanubi, wherein the court elaborated on circumstances that the claim of quantum merit is appropriate and applicable. My Lord, the court held that a claim of quantum merit is applicable wherein a contract has been frustrated or terminated or performance has been rendered incomplete. My Lord, by the provisions of this law, it is settled law. It is tried that the doctrine of quantum merit seeks to allow a party to claim a reasonable amount for the value and quantum of services rendered, my Lord. My Lord, in applying this rule to the fact in issue, it is clear, my lords, very clear, without any ambiguity. It is in no doubt that the petitioner in this case has performed substantially his part of the contractual agreement, which amounts to 80%, my Lord. My Lord, emphasis on 80%, not 10, 20, 30, 50, but 80%. My Lord, for the claimant to have achieved substantially 80% means he has utilized money, resources, skills, knowledge, and every available manpower in order to achieve 80%. My Lord, the contract was merely frustrated. It is obvious, following from the facts of this case, that there was a subordinating event that was subsequent after the contract has been formed, my Lord, and the imposition of what? Lockdown by the president, which even if my Lord was declared to hold for 21 days, subsisted subject to the further orders of the president. My Lord, this means that even in the time of the contract, restrictions were on the part of the petitioner to complete the remaining 20% of his contractual obligation. My Lord, the petitioner's non-performance of the remaining 20% is solely attributed to the national occurrence of the COVID-19 outbreak. And this is unforeseen and unavoidable circumstances which both parties could not contemplate. It is in no doubt that the petitioner in this case has performed his own part of the agreement until the occurrence of a natural outbreak, my Lord. My Lord, it is clearly even seen that the party engaged in further communications with the respondent to honor his agreement of the remaining 20% of his contractual obligation. However, these restrictions constrained him to fulfill the remaining part of his obligation. My Lord, in the absence of such a frustrating event, it will be right for any reasonable man to think that the petitioner would have been able to complete the remaining 20% of his contractual obligation. My Lord, the supervening event was beyond the control of the claimant and is beyond the control of the petitioner and is neither a fault of the parties. My Lord, denying the claimant in this case for compensation for 80% of his performance will be considered unjust, unfair, and contrary to the principles of natural justice, my Lord. On this note, my Lord, we humbly submit, based on the relevant facts, authorities, and rules of law, that the contract was merely frustrated, and the petitioner in this case is entitled to a claim of quantum merit on the basis of 80% performance, my lord. It will be therefore unreasonable, unjust, and contrary to the principles of natural justice to deny, deprive, and disentitle the petitioner in this case of his claim of quantum merit. We so humbly submit, my lord, to grant the claim of quantum merit to the petitioner on the basis of 80% substantial performance, my lord.
Thank you, counsel.
Thank you, my lord.
Thank you.
Yes, ma'am. Yes, ma'am. Let me answer. I want to ask you for the petitioner, right? Now the contract, they don't make room for the effect of supervening. Are you following me? The effect of frustration. They do make a provision in the contract that when certain things happen, what will happen to the contract?
No, my lord. It was not expressly provided, sir, my lords, in the contract agreement. However, the occurrence of this supervening event was unavoidable. My lord, it was unforeseen by both parties, my lord. And therefore, in a situation as such, where the contract is frustrated by a supervening event such as the COVID-19 pandemic and the restrictions, the parties
Go ahead.
are further discharged from their obligations, my lords.
Thank you.
As the court pleases.
What we are collecting is just a short comment. Again, we are very impressed with your presentation. I can see that this is my curriculum. This desk, they exhibited huge oral and non-verbal communication skills. And both of you were really attentive to the bench and had some good interaction with the bench. Because you were a master of the work you had prepared. Very well. Just a few comments. From this side, I think the lady said, I vote, not for you to vote, for you
To submit.
For you to submit.
Stand up when the court is addressing you. That's the proper thing to do.
So generally, we think you've done very well, but my Lord will not give us the general marks and final decision. So after this session, they will bring in
No, there's no. Can we have the attention of Mr. Sigo here, please? Give us about 5-10 minutes.
That's complete.
Yes, as my learned brother Justice Harriman just said, you all did wonderfully well. But we know very well that there must always be a winner. So we proceed to call results. Delta State University, your case title, we scored both schools, Delta State University and Michael and Cecilia Ibru University, 1. Then side title, both of you 1-1. Year of case, 1. Name of court, Delta State University scored 2, while Michael and Cecilia Ibru scored 1. Team code, we gave 0 to Delta State University because they didn't indicate it. Michael and Cecilia, 1. Articulation, Delta State University, 8. Michael and Cecilia Ibru University, we scored you 9. Knowledge of facts and law, Delta State University, 7. Michael and Cecilia Ibru, 8. Overall presentation, Delta State University, 7. Michael and Cecilia Ibru University, 8. Flow of argument, Delta State University, 5. Michael and Cecilia Ibru University, 6. Clarity, Delta State University, 6. Michael and Cecilia Ibru, 7. Dressing, Delta State University, 3. Michael and Cecilia Ibru, 2. Depth of research, Delta State University, 7. Michael and Cecilia Ibru, 6. Ability to answer questions, Delta State University, 3. Michael and Cecilia Ibru University, 4. Delta State University scored a total of 51 points, while Michael and Cecilia Ibru University scored a total of 55 points. making Michael and Cecilia University the winner in this round. In the first round, we had Edwin Clark University coming up at first. So what we are going to do now, we will call Edwin Clark University and Michael and Cecilia University. Instead of going to carry out another form of argument, we ask you questions. The reason for this is this. When Edwin Clark University commenced the argument, they were the petitioners, and Michael and Cecilia University are also petitioners in this case. So it's not a question of saying go and swap. If it had been the other way around, it would have said, okay, swap, let us hear you. So this is why we have to ask questions to know who the winner will be. There must always be a winner, no matter what. So that's what we're going to do. Once again, I must commend all the team. They did extremely very well. You presented your cases and you made submissions and answered questions as if you are really practicing legal practitioners. We are impressed. We're very impressed. Please let them come and take their seats so we can ask them some questions. My colleagues will do the questions. Thank you so much. You have to dress properly. It's much of.
As for my this is Hebrew University, I will ask you a question which relates to the submissions to make this work. How does the constitution of country A becomes applicable to country B?
Thank you, my lord, for that very good question. My lord, reference was made to sections 46, sub 1 and 2 of the Nigerian Constitution of 1999 as amended. However, that section is merely of persuasive effects in respect to this particular case, my lord. So submit.
Are you referring to the Constitution as a kind of not that, just a persuasive authority. The Constitution of the ground rules.
My Lord, yes, it is rightly asserted that the Constitution is a ground norm. But my lords, presently we are not in Nigeria. This is the High Court of Kara, because the facts of the case stated that the present application is filed in the High Court of Kara. And thank you, ma'am.
My question, for the benefits of some of us who I don't know much about arbitration, I understand you did a lot of research. You did a lot of research. How can one challenge the appointment of an arbitrator?
Thank you very much, Worship. Lord, by virtue of Section 9, the Arbitration and Conciliation Act of 1996 of the Kara Republic, which is equally material with Section 9 of the Arbitration and Conciliation Act of Nigeria 1996, calculating LFN laws of the Federal Republic of Nigeria 2004. The party, the petitioner can challenge the impartiality of an arbitral body if and only if there is a justifiable and apprehensible evidence of bias. So if I relate to the circumstances of this case,
but just a second, when you challenge, who takes a decision whether you're challenging?
Thank you, Your Worship. By virtue of Section 9, Section 3, the law, according to the Arbitration and Conciliation Act, it is categorically clear that if a challenge, if an objection is raised by any party, and the other party does not consent or agree to such objection, that the arbitral body has the jurisdiction, the power to determine such objection. That's the position of the Commission.
Thank you very much.
Thank you. Thank you, Madam.
Okay, thank you. Michael and Cecilia, Hebrew University. You said the Constitution of the Federal Republic of Nigeria is of persuasive authority. Meanwhile, you are from Kara, Federal Republic of Kara, and you are appearing before the Kara High Court. Does it mean the country called Kara has no constitution? Okay. You want to answer? Okay, try.
The facts of the case did not expressly state that the laws in Kara is pari materia with the laws in Nigeria, under which we can presume that all our laws will be in tandem. And it is what the strength of that presumption that reference was made to that section for persuasive effect, being that Kara is a sovereign state separate from the Federal Republic of Nigeria.
I thought I should ask a similar question about arbitration. God is talking to you. So you recall that your colleague said that the arbitral tribunal will take a decision as to whether or not the arbitrator is eligible, is qualified to carry on with the case. If the arbitrator decides overruling the objection, what options do you have if you don't agree with the decision of the arbitrator? What options do you have? That is, if you're not happy, you challenge the arbitrator and he says, no, I'm qualified, I don't care if I went to the same law school with one of the parties. So I'm ruling that I'm qualified, I'm not biased. That's my ruling. Do you have any, because you have any option, what can you do, or just continue to participate in the arbitration?
My Lord, I will refer my Lord to sections 8, sub 1, 2, and 3 of the Arbitration and Mediation Act, which provides for how such circumstances can be handled. And My lord,
Is
that's
my question clear?
Yes, my lord.
Because a lawyer, you always look for a solution to a problem. So what would be, you are not happy, what would you do?
My lord, the sections I earlier mentioned, it provides that a party who is aggrieved about the ruling of the official panel with regards to appointment of members can approach the High Court, my lord.
I mean, this year are too much. It's really unbelievable.
Yes, Team Delta State University. Oh, sorry. This is Edwin Clark, right?
Yes, sir.
Very sorry. Okay, sorry. Yes, I earlier posed a question to your opponent. I asked them. They were saying the section 46 of the 1999 Constitution of the Federal Republic of Nigeria is of persuasive authority since they were in Kara Republic. And I asked them, is it that Kara does not have a constitution? So perhaps, if they don't have, what would you, I don't know whether you will say yes they have or not, but let me bring a second prong of the question. Assuming they don't have, what would you have been able to do so that the court can apply the Nigerian constitution or Kara? Yes.
If I got your questions, you say that with the assumption that the Republic of Kara does not have a constitution, what I would do for the court to apply?
The first question is whether Kara has a constitution. Because none of you referred to any section of the Kara constitution. So my first question is, does it mean Kara has no constitution? So what will justify you if it doesn't have to now use that of Nigeria? That's what I'm saying.
Okay, thank you, my lord. In response to the first part of the question, my lord, this is a hypothetical scenario that was painted with the fictitious name, Republic of Kara. My lord, in instance of our appearing before a court of competent jurisdiction, which was established under the Constitution of the Federal Republic of Nigeria, the assumption is that the Constitution of Nigeria is same as that of Ghana Republic. We can validly rely on the provisions of the Nigerian Constitution, deeming it to be the same as that of Ghana Republic.
Okay, you may sit down. Let me put this by way of suggestion. You rightly said that it's a hypothetical case. In case of next time, perhaps it would have been better for you to say, the section 46 of the Federal Republic of Nigeria also applicable in Kara. That would have covered you.
Properly gathered, my lord.
Thank you.
Yes, for your student, now, when you file a matter at the court of first instance, if you are the person that initiates the action, or you are the person that was sued, how do you refer to yourself?
All right, your worship. But I will answer this question in broad categories. First of all, if you are appearing before a customary court, I'll start from the lowest court. The first instance, in this case, the court of first instance, just as before the Federal High Court. So I will be referred to as the plaintiff, whereas the other party is known as defendant. For where it is an appellate jurisdiction, I will refer myself to as appellant, whereas the other party will be referred to as respondent. So the reason why we involve the defense, claimant, appellant, and defendant respondent is on the assumption that the instant matter is an appeal against.
God please.
Yes, thank you so much. I'm sure, okay, let me show my colleagues. Both schools, they've done so well, but there must be a winner. And for Edwin Clark University, you scored 8, whilst Michael and Cecilia Hebrew University scored 9. So, the overall position, Michael and Delta State University came out 3rd. And I must say the fact that you came out well, they mean that you didn't do well. You did extremely well. You did very well. We are very impressed. Adrian Clark University 2nd. Michael and Cecilia Hebrew University 1st position.
Thank you very much, my noble lords. On behalf of the defendant respondent, we are most grateful.
Thank you so much. These children will go places. I am more than impressed.
We are most grateful for the wise decisions.
Thank you.
Very, very good.
Thank you.
And in fact, for speaking for myself, this event has exceeded my expectations, honestly. And I was just telling the chairman and when we are this stage in our days, I'm not sure any of us are as sharp as this. No. So, even on my Lord.
It means that there is hope for the profession. There is hope for the profession. But before we round up, sir,
While we were considering the 1st and 2nd, my Lord Honorable Justice Akpor will walk in. And I think it's only fair that we give him the opportunity of saying a word or two to the young students who have performed
extremely well. So the Lord Justice Akpor was allow you to.
Okay, my apologies for coming late. I didn't disclose this morning, but I promised the barber that I would be here by inviting others, and I felt if I invited others and I didn't come, that would not be a good role model. So that's why I'm here, and I was keeping in touch with your passport to say I'll be there. Now, I must commend the NBA first for choosing the occasion of the 100 years to do a program like this, and including the younger generation coming up. The other thing I want to say first is, all of you, congratulations. You are all winners. And then to also say that we hope more of this can be encouraged by individuals sponsoring this event within the different universities and faculties of law. That will help people to sharpen more your experience in areas like this. I always said to the young ones coming that your daily experience and your observations in life are built up not in one day. There are some things that have no textbook. You only
some have no answers to certain things you meet along the line. You just find out that, for example, the manner of a judge in one court is different from the other. That is got to do with the personality of the judge, and there's no textbook that's going to solve that one. So you need to key into the future by starting well with your little beginnings. And your little beginnings must be one in which you have confidence that there's a hope for tomorrow. Believe in yourself, have confidence in yourself. And once you have confidence in yourself, the next thing you must remember is that there must be due diligence in anything you do. I would rather have a diligent student than a first-class student who is not diligent. I always said that. So some firms today, law firms, have the bar 2-1, low first-class or without employed. I said they are wrong. They are not getting the best products. So I also say to my students who are lecturing in Delsu Pro Bono that do not doubt who you are. You will always achieve when you believe in yourself. Everybody has a different destiny. Some of you are going to end up in the bench, some of you senior advocates, some of you in practice, some of you end up in personnel, human resource, because you have skills in administration. So I wish you all well. And I thank my elder brothers and Prof. and all who have taken part in the MBA leadership, landscape. I say well done. God bless you.
Thank you very much, my Lord. Now, just before we leave, we want to present certificates of participation to all the students who have participated in this trial, because this is what will remind you tomorrow of what happened today. 30 years from now, you look at this, you show it to your children, and to remind you of today. It's not about who came first or second. As far as I'm concerned, everybody came first. That's my take. So I want to start by calling on the former Attorney General of Delta State, the life bencher, Mr. Charles Ajuya, to present certificate of participation to the students from Delta State University. So when you hear your name, you stand up and come and collect your certificate. Inyoma Ogenekawi. Is he here? Dr. Brown, come and collect this one. Is he here? Come on now.
This certificate of participation presented to you, in recognition of the participation in the good and moral health and the celebration of 100 years of people practicing law, issued on the 8th of June 2025. You may sign.
The next person is Ogene Mega Manasseh. Yes, that's our lead counsel. Yes.